All right, we are back on MorningLine. Our guest is Tim Takacs, elder care attorney. The phone line's open if you want to jump on the line, 737+. If you have a question or comment from, what else are you dealing with these days, Tim? I know I'm not sure if it comes into play with what you're dealing with, but do you get any questions as you approach tax time in the 15th with some of the folks you're dealing with, one way or the other? Maybe they've transitioned to Social Security, or they're wondering if they need to file, things like that?
We get a lot of questions around, like I say, right around this time.
Yeah.
We draft a lot of different types of trusts.
Okay.
You know, and so people they set up a trust, they put money into the trust, you know, and without belaboring too much about what a trust is, you know, it's like the bucket we've talked about. You know, you put money in a bucket and somebody's holding the bucket for you or for somebody else.
But what does it do? What is keep it off limits for something if you put it in a trust? Why not just leave it in a bank?
Yeah, because so here's the most sort of the basic thing is that okay, I've got money and I've got a house. I'm going to transfer it to a trust. Okay, so Lynn and I, my wife and I, are trustees of our own trust.
Okay.
You know, and the trust says that when we die, you know, the money, whatever's in the trust, gets titled to other people. Okay. Family members, whatnot. Yeah. Okay, so Lynn and I die, you know, and whatever's in the trust doesn't have to go through probate.
And the reason you want to avoid probate is that's lawyers. There's some costs.
There are some costs. It's not a big deal, but I mean, as long as you can avoid it easily by using a trust, which is simple to maintain.
Again, you're so good at explaining some of the basic things, and you and I, that's second nature too. But to the viewers, probate, and people have heard of probate court.
Probate is court-supervised estate administration,
and they step in when you haven't spelled it out.
So Daddy dies, you know, and you take the will to probate court, thinking, well, Daddy, you know, so you go to a lawyer, and the lawyer says, I'm going to charge you thousands of dollars to do the probate. You know, it's like, well, Daddy only has a house and like a few hundred, you know, maybe $100,000 or whatever it is. It's like, well, we're going to go there anyway. Yep. You know, when you could have avoided that, because you don't need courts. Most families don't need court supervised estate administration.
It's not some monstrous giant estate.
And there's no dispute. You know who the creditors are. You know, mostly it's to assure that there's an orderly distribution of the estate to
So if you leave a good, clear will and trusts may be set up, you don't have to have a trust, but if you have a very clear-cut will.
Well, a will, remember, a will is, that's like a written instruction. Yes. How does property pass at death?
Yeah.
You know, one is that all to ma, you know, you write it out on your envelope. Yeah. You know, and then it's like, you know, so your children pull it out and it says, you know, all to ma or whatever it is. Well, wonder who that is. Daddy must have wrote that. Yeah. You know, so you take it to the judge, and the judge goes, well, where'd that come from? It's like, well, it was in Daddy's drawer, and it says all to ma. Is that your dad's handwriting? We says, yeah, it is. So I guess everything to ma then, because that's what he wrote, all to ma. Well, now, so then the probate court goes, okay, tell us what Daddy owned. You know, so we do an inventory and all that. Well, do you really need a judge to do that?
I guess not, unless there's a dispute among the
Exactly.
heirs.
In most cases, there's not. No. We know everything goes to Ma, you know, and it was in Daddy's name, you know, and if Daddy had put it into a trust so that when he died, Mom would get it automatically, we'd have to go through that.
Okay.
You know, so trust is basically a legal way of somebody owning, you know, holding property for somebody else.
I gotcha. Okay.
You know, so that's kind of the short, you know, that's
okay. So putting trusts together, things like that.
You know, and so we get questions from people, well, I've got money in a trust, you know, do I have to file a tax return? Does the trust have to file a tax return? It depends on what kind of trust it is. Some trusts you do. You know, most kind of trusts that are revocable trust, or what some people refer to as a living trust, you don't have to file, the trust doesn't have to file a tax return. Okay. Because IRS don't care. It's still your money as far as the IRS is concerned.
Right.
But if you're setting up a trust, let's say you've got a child who has a disability or special needs, and you've set up a trust for that child, you know, and there's a trustee that's holding the money in trust for that child. The trust will file a tax return.
Oh, okay.
Because you don't own the money, because you put it into a trust for your disabled grandson or whatever it is. The grandson doesn't own the money, because if he did, he couldn't get public benefits. So now the trust owns the money for the benefit of that grandchild. You know, and so the trust will earn income. Okay. You know, so somebody has to file a tax return.
You're filing that. I was wondering, it's on the interest or the income that the trust earns.
It doesn't mean the trust has to pay the taxes on it, because it could be taxed to the beneficiary of the trust.
Right.
It just means that the government needs to know, okay, this entity called a trust, earned income, interest income. So we need to know about it. So you file the trust files a tax return. Often it's information.
Okay, that makes sense. And we have a caller actually with regard to a difference on things. Janice, go ahead. What's your question, Janice?
Yes. What's the difference between a trust and a will?
Okay. Yeah, we're kind of touching on it. Good question.
Yeah. Okay, so this gets back to, like we talked, I mentioned about the ways how property passes at death. Okay, there are basically 3 ways that property pass at death. One way is what we call by operation of law. All right, so you're married, hopefully still.
So far.
So far, so good.
She hasn't killed me yet.
Right. And you and your wife, you own real estate together. You own bank accounts together. Okay, so Nick, you pass away, and any assets that you own that you and your wife own jointly pass by operation of law.
Just automatically
to her because she's on the title too.
All right.
Or if you were not married, and let's say you were widowed and you died, and by operation of law, your house would automatically go to your children.
Okay.
You don't have to do anything to make that happen. The way I often put it is people have been dying for centuries, owning stuff, and somehow it gets to their family.
Yeah.
Without creating too many problems.
Yeah.
Now, so that's one way property passes. Second is it passes by an instruction.
By the way, what if the children are minor, by the way, when the parents die?
Then a guardian
there
takes over.
There would be like a guardian appointed on their behalf.
Because minor children can't own anything.
That's why that's a good question. I was just thinking then.
Yeah, so if it's a 2-year-old or a 15-year-old or whatever, they can't own anything.
So a guardian could be another extended family member.
So that's when maybe a court gets involved as a guardian gets appointed.
Okay.
Okay, so the second way property passes is by a contract. Okay. Beneficiary designations on life insurance policies, retirement plans. You have a beneficiary. I die, pay my wife. You have a contract with your life insurance company. And so that's the contract that you have with them.
Yeah.
Okay. The third way is a written instruction. That's a will. All right. Okay. The contract way is the trust. You have an agreement with the trustee, you and the trustee, and it basically says, I'm gonna title my property to you, under an agreement, and when I die, then I want you to leave it to somebody else, to these persons.
But that sounds like a will.
That's almost is, but it doesn't have to go through court.
Oh, okay, that bypasses the court. Those wills can end up in court. They can go to probate.
Right.
Okay.
That's the thing. It's kind of like the contract thing is that if I give my retirement plan to you and you hold it for me, and then when I die, you're going to pay it to my wife. Right?
Gotcha. Right.
Similar to a trust.
Okay. So
you don't have to go through court.
Let's see. Let's go to Evan, who may receive these questions along these lines. Evan, good morning. What's your question, Evan?
Yes, my question is, I understand when people die and leave their assets to their beneficiaries, the government wants tax on the property because of capital gains. What can happen if someone dies who has a lot of property but very little legal tender leads into a poor family and they don't have any money to pay tax on all this property with fair market value?
Okay, that's an interesting question.
Okay, so I didn't quite catch that.
Okay, it sounds to me like what if you were the question will be, I guess, inheritance tax or capital gains. Yeah. If a loved one dies and leaves you not money, but leaves you property, and you don't have the means to pay the taxes on that property, what do you do?
Okay, here's what happens on that. Okay, so you bought a house 20 years ago and you paid $100,000 for it. Okay, and now it's worth $300,000. Okay. All right, and then you die and you leave it to your son. Okay. Now your son inherits it. All right, is there a $200,000 capital gain difference between what you paid for it, and what it's now worth at the date of your death? No. Because when your son inherits it, he gets the date of death value. That's the tax basis. So if he turns around and sells it, the next day, there's zero capital gain.
Zero capital gain.
Now, but if you gave, let's say, 2 weeks before you died, or let's say 6 months before you died, you said, okay, I'm going to give my house to my son because I don't need it anymore. So you give $100,000, so it's worth $300,000, but you bought it for $100,000. So you give the house to your son for and then he turns around after you die and sells it. Guess what? $200,000 capital gain.
Capital gain. So the
death is good for beneficiaries.
By the way, I don't know if he was also talking about, are there any other costs that would incur if you are not, if you don't have the means and you inherit something like that? I don't know, you may have property taxes and everything else. All of a sudden, you're going to have to pay on this chunk of land that someone just left for you. And if you can't afford it, that might mean then you have to turn around and sell the land to pay for it.
Well, it's like you know, you give your house to your son, you know, and then he decides, well, okay, you know, I sell a $300,000 piece of property that's got a $100,000 tax basis. It's a $200,000 capital gain. He doesn't owe it until he sells it.
Until he sells it, right. Okay.
But then he might curse Daddy and going, well, I wish I'd have told Daddy just to
hold on to
wait till he died.
Yeah, wait till he dies.
I'd rather inherit it.
Okay. Yeah, big difference there.
That's a big difference.
Death is good for capital gains.
Death is good.
All right, we'll take a break on that note. When we come back, more of your phone calls, some good questions right after this for Tim Takacs.